All right, welcome everyone to our conversation on digital justice. The questions we're going to be asking is really, how does the digital age transform our notions of justice? And how should we even conceptualize the social transformation that's been brought about by the digital age in order to begin to think about how it might affect justice? In their new book, Justice Digitale, but I think we could also say it in English, Justice Digitale. I think that sounds pretty good. Antoine Garapon and Jean Lassègue take a unique perspective on the digital transformation itself. In other words, on the transformations of the digital age itself. They refer to it as a graphic revolution, a revolution in writing, based in part on a mathematical paradigm, I think, or mathematical language that really strips the world of its current significations. And that's a very important piece of their thesis, that this stripping of the symbols that we've lived with for so many years has effects. It allows the algorithms, the code, the artificial intelligence to gain a kind of authority that trumps human judgment. And so just to read a passage from their book, page 99 of Justice Digitale, and translating here, this mutation signals a new regime of beliefs, of believing, régime du croire, a new regime, one could say a regime of truth, a regime of the way in which we come to believe things. Our contemporaries are no longer impressed by the symbolic attributes of the function, but are more inclined to believe numbers that inform them on, for instance, rates of satisfaction of a service or other things. Today, the public is more reassured by a truth established through the bias of algorithms than by a human decision. And so that gets at the heart of their intervention, which is the way in which mathematical logics come to displace judgment. And I would add that ultimately really gives an extraordinary amount of power to those who write the code. Now, in order to unpack this and to explore these theses, we're delighted to welcome to Columbia the authors of the new book, Antoine Garapon and Jean Lassègue. Antoine Garapon is one of the leading magistrates in France and the founder and director of the Institut des Hautes Études sur la Justice, which is the Institute for Advanced Studies on Justice. He's a prolific author. He's recently published a book called Democracies Under Stress with Michel Rosenfeld in 2017, and also published Le Procès Civil en version originale, France, États-Unis, Chine, with Daniel Schimmel, who's here today. Jean Lassègue is a colleague from the École des Hautes Études en Sciences Sociales, the Institute for Advanced Studies in Social Science, where he's a member of the CNRS and at the Institut Marcel Mauss. And he's done remarkable work on Turing with a book on Turing, who, of course, is at the foundation of many of these inventions that have brought about the digital age. So the way we're going to proceed is I'll ask Jean and Antoine to present the theses of their book, and then we'll have a conversation and open it up for debate and conversation. So welcome, Jean, Antoine. And Jean, why don't you start?
Okay, yeah, right. Well, thank you for having us. Thank you, Bernard. And thank you for coming. So, yeah, how to present this book written by four hands. So I think that, yeah, the first thing is that we didn't start with philosophy of law or politics, but we started with philosophy of science, which is, my specialty. And so we tried to have some kind of mixture of philosophy of science and anthropology. to try and make some sense of this computation and revolution and the digital consequences on law and justice. There's one author that you didn't mention, which really brought us together, and who was quite a figure here in Colombia. That's Ernst Cassirer, the German philosopher who died actually in 1945, just outside Colombia after a lecture. Why is he important for us? It's because he was first a philosopher of science, and then he developed a kind of philosophy of culture and anthropology, and this is this very movement that we tried to reproduce in the book, trying to find out more about computation and trying to see what kind of anthropological consequences we could draw. So the figure of Cassirer is certainly very important. So I think that our take is I would say philosophy of science plus anthropology of law in the age in the digital age. So you mentioned the notion of graphic revolution, which is the subtitle of the book, and what do we mean by that? It's essentially a very large movement that started, in fact, in Leibniz's works in the 17th century, which is a movement of formalization, and this is very important because from then on, computation became really something important in science, and to make that possible, a scientist had to have a clear picture of what computation is about. And as a matter of fact, mathematicians have been computing many centuries, since antiquity, but the concept of computation was not a mathematical concept itself. So it became a concept in the modern age, and that's where a computer comes from. So it's really important. So what we try to underline are in fact two facts. First, something about literacy, the fact that all of a sudden, I was brought up a French intellectual, and all of a sudden I'm totally illiterate. I can't read a code, and in any interaction that which is not face-to-face, just like now, I need some kind of digital mediations, which means that I'm dependent on computer scientists and IT people all the time, and for all social interactions. So that's the first thing. How is it that all of a sudden, most people become totally illiterate, and what kind of social dependency this implies? So that's the first point. And the second point was to imagine some kind of history of computer science and of computation by putting it back into the history of writing. So our take is that computer science and the digital age is the latest step in the history of writing. So it's both a revolution, that took place, like I would say 50 years, in the last 50 years, and it has a very, very long history. Since in the West, we've been writing for 53 centuries. If we start in Mesopotamia up to now, that's 53 centuries. So there is both long range and short range take to have at the same time, and this is I think very difficult to take both viewpoints at the same time. So as you said, Bernard, what is new is the fact that law was up to now compiled in texts, and people could read texts. But now law is written in codes, and even the judges can't read codes. So the judges need to have these softwares all the time. They use softwares to predict, to help them decide, but at the same time, they also have to depend on computer scientists and IT in general. So what are the consequences of this situation? So we tried in the book very, very quickly to make some kind of history of writing since the beginning, and we underline especially the alphabetical take in Semitic languages and in Greek, and from there we managed to go to computation and the concept of computation in the 20s. As you said, this concept depends on a clear-cut distinction between meaning on one side, which is completely left aside, and the processing of pure graphic marks. And this is what software is about. And so this has consequences on how to, of course, to read law. And there is, I think, something very new, which is a new dimension of perception. You know, I'm talking now, and you're listening to me, and I suppose that at the same time you had received texts. You know, so there's some kind of intervention of writing just now in the middle of the space that has been shared with us. So there is this abstract and logical dimension that you know pops in all the time, and it makes a very different space-time than the one we are usually used to. So this is something that, of course, has consequences, especially in trials, where people are supposed to meet in the same room for a certain amount of time, where you are allowed to speak if you are given the floor, etc., etc. So what is important for us is then that there is some kind of competition between various forms of authority of law. And one is the textual one, and the other one is the code. So how does it make things different? Well, I think first that the big difference in law is the de jure de facto. I don't know how to translate this into English.
You use the same terms.
Okay, you use the same terms.
De jure de facto.
Right. Yeah. So and obviously now, you know, we have statistics all the time. We have evaluation all the time, and this makes a big difference, because what is more important than law is more the behavior of people, which is the main object of statistics. So the first distinction between de jure and de facto is somehow blurred, but also the difference between public and private, you know, private sphere and public sphere are totally interpreted in a different way. I mean, you know that better than me, Bernard, so I won't talk too long about this. And it comes. So the consequence of this is that the notion of third terms which are instituted, you know, institutions are not trusted the same way as before, and in a way there is some kind of hate towards institutions. So why is that? Because we think that technology is able to replace these institutions in many ways, and of course I think this is purely ideological, and so we have to be very careful about this. So there is a kind of mistrust in the state, a mistrust of any symbolic mediation, and of course a mistrust of people also. You know, the digital age is the age where everybody can avoid everybody, and where of course you can live in a very comfort zone of your own circle, with avoiding I don't know, I mean poor people, or anyone you don't like or you don't feel like meeting. So there are many basic categories in law and justice that have been changed through this digital revolution, and I'm sure that now Antoine can talk a bit more about that, and I can.
Okay. Good. Thank you, Jean.
Okay.
So let's move to the
Right.
implications for
implications,
justice.
because I'm a judge, and so I was a practicing lawyer, and to me what happens today with digitalized justice is a lot of revolutions, not only one revolution, but a lot of revolutions. The first one is, I don't know what would happen in the US, but in France there are young geeks, people that are engineers, not trained in law at all, and they saw that there were a market, a very huge market of legal services, and they want to get this market. And they say there are lawyers, old-fashioned lawyers, that they are rent seekers, and they are all. We want to get this market, and because and it's very important to in France, because the law is not made for the people. Law is an institution, an old institution, which is made for lawyers and judges and perhaps law professors, who knows, and we are taking this market of legal services through new tools. And these new tools, I think we cannot understand those tools if we do not understand that the argument behind those new tools is that they fit more with the ideals of democracy and justice. Mm-hmm. And we are creating a new access to justice through these tools. It's a real revolution, which is a social revolution. The young versus the old people, the access to justice versus the rent seekers and the rent of lawyers, and through internet we can bypass all these institutions that putting gatekeepers that was who the lawyers were. So a social revolution. A second revolution, it's an epistemic revolution. Epistemic revolution, which is Jean spoke a bit about. Epistemic, it means that we do have now new ways of enframing reality. And I'm sure that in Colombia it's exactly as what happens in France. The lawyers, they are trained in law. What is law? It's written stuff. We have to read law. We have to read and to comment, to give just interpretations of law, or to defend our clients through written arguments. But the very basis of law, which was text, is threatened by algorithms, and now we have new tools to know what's the law for lawyers, what's the law of these books, but the law as what judges would really decide on a case. And it's a very strong argument, because as Justice Holmes said, and it's the basis of the movement of legal realism, Judge Holmes said, what is the law? The law is what judges would decide in one case, and that's it, nothing else. A friend of mine, who is a very clever lawyer, he understood very early in advance how important were these tools, and he, for kind of cases which are the labor, what is licenciement?
Firing.
Yes. It's a very hot issue in France. Well, I can forget the law. Just look at what happens. What do French judges decide on those cases? And he designed a curve. He designed a curve. Mm-hmm. And the law of the end of contracts in France, it's a curve. And the curve, we can very easily understand that at the beginning of the curve, the longer you stay in a firm, the more
More money you get.
more money you get.
Right.
And then it's stable. And at the end of the contract, there is it's very counterintuitive. There is a decrease of the compensations given by judges. So this is the law. And when you receive a client, it changes everything, because the negotiations are thought, and the defense are based on this curve, not on law. And it works very well, because he trained a robot to do that.
A robot, right?
Robot. Yes.
Right.
Robo?
Yeah. Robot, yeah.
Robot, yes.
Yeah.
And so, total change, because for us now, as a lawyer, what is this curve? Is it law, or is it a fact? And that's the point. Jean made, that there is a blurring of the very basic distinctions between matter of fact, matter of law. And to go directly to my point is that we are now the lawyer. We must learn the law. Then we must learn case law, how law is enforced by precedents, by judicial decisions. And we have to know how to use IT and this digital technology in order to give a new kind of information to our clients, which is the let's say, predictive justice. Predictive justice as a word which is not exactly predictive, but it's a very important perspective. And then there is a symbolic revolution, the third revolution, social revolution, epistemic revolution, and a symbolic revolution. Because our authority, we got our authority as lawyers from our ability to deal with text, to interpret those texts, and to combine an institution with cases, with real cases. And it was true for universities, for courts, for legislature, for the parliament. And this combination, law as a combination between an institution and a text, is totally destroyed, we could say. Destroyed because now let me take an example, which is a real example. There was it's your example, in a court in France, there were a public prosecutor and a judge, a sitting judge, in a trial, hearing witnesses, and they were friends, and the prosecutor sent a tweet during a hearing, commenting on the witness statement with the judge. So it was impossible before. When you are in a traditional setting, it's impossible to communicate. You have judicial rules. The one is to prosecute and there is no cross-examination in France, but to give evidence. And the other role for the judge is to remain silent and to wait for the end of the trial to decide, with retiring with the jury. And it has been taken by the way it was taken by another judge who denounced this fact, because it was an abuse of the judicial procedures. So the ritual, the judicial roles are totally not destroyed, but troubled by this new technology of enframing technology. So I speak only for the judicial judicial sphere. There are many,
Right.
many other considerations about the law and about the idea of justice, but I prefer
Yeah,
stay
yeah.
here.
Good, good, good. Well, you've put a lot on the table, so, and there are a couple of pieces that I want to pick up on directly. Maybe the place to start is to try and understand the notion of a graphic revolution.
Right.
Okay. Before we turn exactly to questions of predictive justice and justice, but the idea of a graphic revolution, which is very provocative and really interesting. A graphic revolution based in part on mathematics as the model by which the communication is taking place, or at least the logic of the writing is mathematical in nature. Now, I'm wondering, I feel as if it might be necessary to separate out two phenomena here. One is the use of mathematical algorithms to produce predictive models. The other is the use of code to create kind of the software that makes possible the new material that we're writing with, which is Word or Word Perfect, or and it seems to me that those are different, that they have different effects, that they both could be thought of as kind of a revolution in writing or a graphic revolution, but that I think we need to think about them separately, even though they are the product of the same thing, of the same developments. The reason is that, at least with so the first being the algorithms to predict dangerousness, or to predict dangerousness, or to read materials, discovery materials, say, CDs coming in with tons of information, and the algorithms that try to read that for us and interpret it for us. Now that, it seems to me, is going to have significant effects on us, because we're going to believe the algorithm, we're going to trust the algorithm, we're going to rely on the algorithm, and so this ties to notions of actuarial justice. Actually, I mean, we're going to believe those algorithms because it allows us to not be responsible. Say, right? You've got to sentence someone. It's not a pleasant task. You don't really know how to do it. Now you can rely on an algorithm that tells you that the person is dangerous or not dangerous. Right? You've got to release someone on parole, right? That was a lot of responsibility. If the person went out and committed another crime, you as the judge would be responsible for that decision. Now you can rely on an algorithm, right? So that certainly changes our relationship to justice. Now, but the other graphic revolutions, which are the creation of this world of IT, this world of word processing, and all of the other forms of IT that you were mentioning, it seems much more hidden and having less necessarily of an effect on our own judicial writing or on our own judicial decision making. It's almost, those innovations and revolutions at the writing level seem more like a technical development in what happens inside a pen, right? I mean, you're using Word to write your decision or to make an argument, but the technology and the algorithm doesn't really affect, or does it? I don't know. I mean, it doesn't feel as if it affects in the same way. Surely it has. So we write differently when we write manually with pens and paper than we write when we use word processors. We cut and paste when we use word processors in ways that we don't cut and paste. But I'm wondering, it doesn't feel as if it has as much of a displacement of human judgment as the first category. And so I'm wondering, within the notion of graphic revolution, of a revolution in writing that is reflected by the digital innovations, we would need to separate out different categories and to think of them differently, separately, and not kind of it's not all just one big thing. What do you think about that, Jean? To start with?
Yeah, well, it's a good idea. I haven't thought of that. But first of all, I'm sure you're right about the use of software. You were mentioning parole. There's been a big scandal about one of these software in the U.S. called Compass, because it had racial bias, and so there was...
right. So yeah. Now, I'm wondering, okay, so how does that fit in the notion of a graphic revolution?
Well, as you said, there's a trust in algorithms.
Yes.
There.
Yes.
And is this trust justified or not? And
right.
Of course, there is so much data today that we can't. We have to use software. Otherwise, there's no way to deal with them. So that's certainly a big issue, and it has a lot to do with the trust in algorithms and in justice in general. But you're right by saying also that it's not the same with word processing, things like this, because the opacity is not the same. But at the same time, I mean, it is because we are word processing all the time that the amount of data is getting so large that we have to use algorithms to take care of them. So is it possible to really separate the two? I can see the difference, but there's one machine that, in fact, feeds the other one. And I was thinking of you mentioned Word, this software, but just think of the texts you were writing like 25 years ago. You just can't read them anymore because the software has evolved in such a way that you need an archaeologist to read your own texts. So this is also some kind of opacity that, of course, you didn't have with a pen.
Do you want to
yes,
on this?
Yes. I just wanted to explain what does it change for a judge when you are with a criminal case. Usually, before a criminal case was the problem was to gather evidence, and for judging a man, trying to understand a narrative. The narrative of the crime, the narrative of the motivations of the crime, what happened, what happened. Now with the technology we can use, it's very different. We have keywords, and it was very interesting with judges. We were talking with how to deal with a very big case. Before technology is trying to find narratives and to combine the famous theory of the case. What's the argument? Where's the argument? Now with the system of keywords, you can circulate in a very in a folder just looking through keywords, and there is a deep change in the judgment itself. Because we are expected, with the judges, we are expected to take into account scores. So now, in a French court, you receive, and not only in a French criminal court, also in the French family court, you receive a social report which is presented no longer with narrative of a man, of a family, of a crime, but what are the good points, bad points? What are the risks, and what are the good possibilities for rehabilitation? I don't know what. You know what I mean. So it's a change of the judgment itself because of the technology. Are you with me?
So it effectively changes our thought process.
Exactly.
Yeah.
It changes the thought process because we're able to, because the process of thinking is able to identify different factors more specifically, and you're not forming a holistic view of the case. You're not, and instead you're using keywords to search for certain things. Now, I suppose that before you had those keywords, though, as a judge, you probably had certain places that you looked specifically, right? You had routines to simplify the task, right?
Absolutely.
There would be certain sections of a report that you would turn to first. You might have, depending on the type of judge that you were, you might have looked first at the prior convictions, or you might have looked first at the family of the defendant, or the familial needs of the defendant, or something like that, right? So you would have had, you probably had different kinds of, so you had different kinds of ways of making shortcuts, right? But you did have shortcuts. And so I take it that what the digital platform has done is to transform those shortcuts
and make them
right?
more common. You know, you have categories that are fixed in advance. You know, if you have keywords, it's not your keywords. Not exactly. You know, because
Well, can you choose the keywords, for instance?
Well-
I mean, can you be the one deciding what it is that I mean, in other words, I take it that the keyword for you is going to be what we had before would have been recidivism, or prior convictions, or age, or right. I mean, so. Of course, these things like compass and other parole prediction and other predictions of dangerousness focus on very recurring features, educational level, right, employment, consistency of employment, and things like that. Which I take it you could feed into the keywords possibly. So then the question becomes, how does the use of that change the decision-making process, perhaps?
In a public hearing today, more and more, not everywhere, but more and more, everybody has the file, the folder, judicial file on a tablet, and everybody has the same tablet. And you can circulate into the files. Look, page 252. There is a quotation. The lawyer can make a quotation. Everybody sees the quotation, the same quotation, and he explains and he makes his point. So the way, what I want to say is the way of knowing a case, of discovering a case, which is crucial for judging. How do you get into a case? If you get through a narrative with the opening statements and then the concluding remarks, in France, reading a file carefully, and I had my own, and everybody has its own way of understanding a case, as you mentioned, in order to kind of shortcuts. And my technique was to read the piece through which the police transmitted the case to a judge, because you have a summing up of the case by the policeman. So we say, what is the summing up? So I can see in 2 or 3 pages I can understand the case, and then I go into the file, and my way of judging is to wait for what the witnesses and what the lawyers would add to this narrative, or would destroy in this narrative, would undermine.
Yeah.
And
Yeah.
this was the traditional way of discovering a case.
Right. Yeah.
Now it's
Yeah.
totally changed.
Totally changed. Yeah. I mean, this conversation and this debate and this inquiry into how it changes reminds me of a debate from the 1930s about algorithms or about the use of predictive tools and
Yeah.
how it was changing justice. Now, of course, at the time the digital age wasn't there, but this was at a point at which some states were beginning to use predictive tools with a set of factors. These were developed at the University of Chicago in the late 1920s. And there was an Attorney General of the United States who wrote a report, and I think it was about 1935, which basically said, look, you have all those fancy social scientific systems that are trying to identify the factors. But it turns out that all your factors are the same factors that we were using before to decide that people were dangerous, where they came from, what neighborhood they came from, and whatnot, and that your algorithmic system is just matching our intuitions, right? And therefore, nothing has changed. We don't need your algorithms. We can just continue to use our intuitions. Now, that debate is a little bit is a precursor to this debate in a way about the effects of digitization. But here's one idea which would corroborate, I think, your suggestion. Is that what we see with the use of automation, digitization, or just algorithmic use, is an effort to simplify. An effort to make it more easy, to make it a less number of factors, to identify what's the most important thing. And you've seen that actually as a trend in the number of factors that have been used in prediction tools for dangerousness, that the numbers actually have come down,
Right.
And focus predominantly now on prior criminal history. So it could be that what happens with this process of automation and this process of digitization is that there's an effort to simplify and to identify that then does shift the way we judge things. So that would be one proposal. That there would actually be modifications of the judgment process that are produced by that. I have another idea, which I'll come to next. But what would you think? What would you think of that?
Yeah,
as
I
a
think
suggestion.
I think you're very right. If you take another example, I mean, I'm not a law but a specialist, but if you take literacy, for example, the way text literacy, in the way text would be read. You can see that the analytical way of reading through print, for example, the fact that we used table of matters, and footnotes and things like that, would completely change the way we were reading. And this is there is an analogy, to my sense, with what you just said. So there is a way of getting into a book which is very different when you have these tools like table of content, index, footnotes, keywords, that makes it possible to go from the end to the beginning and see the whole text very differently.
Antoine?
There is another example of what you say is the idea that a machine could provide all the way a word has been used by American judges, either federal or the Supreme Court justices. since the creation of the United States. Nobody can do that actually before automation. It was impossible to do that. Now there are legal tech that say, well, our machines could give a better interpretation of a word of the Constitution, of the American Constitution, because of the ability to review all decisions given by the American judiciary. But which kind of knowledge does it produce? You know.
Yeah.
So it produces a very, very fragmented knowledge, and to me, it's the opposite of the act of interpreting the Constitution. So it's another example to show how too much knowledge, too much fragmented knowledge, changes the interpretation and changing the way of judging, and it's a kind of, it's as if not only the machine would project the idea that the law is only a system of keywords, a system of correlations between words and between elements of judgment and the decisions, and no longer a matter of narrative, no longer a matter of legal causation of a decision.
Yeah. Well, I mean, it offers an incredible possibility for kind of a philology, a legal philology, right? The ability to actually find every case where they use a particular term is an incredible resource. The question is, how does it change? And you're right that it probably changes by moving us away from a narrative that we had and that we were using. I mean, in part because that narrative was built on a limitation, on our own intellectual limitation.
But maybe if I can
Go
add
ahead,
just
yeah,
one
yeah.
thing, on a limitation, but also of something being shared, because you can share a narrative, but you can't share keywords, and so it's.
Yeah. Although you could possibly build another narrative on this, on this richer source of the philology of that concept or that word or something like that.
My idea is that the function of law is an overall in the U.S. It's to provide a constant narrative of the American nation. And this is what the judges and constitutional decisions are for. I admire personally this trend of the American law. So it's a permanent self-definition of the nation. It's a narrative through the method of keywords, through the method of this new interpretation of words and through keywords. It's a function of giving a narrative, of participating to this.
You're saying that it
narrative.
loses, that you're less able to give that
That's
narrative.
it.
So that's a very Dworkinian
Yes.
reading of
Yes.
judicial decision making. But that the use of the keywords would then eliminate that writing of the next chapter.
Yes.
It certainly would discombobulate the stories possibly that have been told, because in part it's possible that those narratives were built on more limited information, and it could certainly discombobulate and challenge and put into question those narratives that we have had. But I'm wondering if it precludes creating another narrative, right? That might have a longer scope or richer texture. But something else, though, that you just brought up that I think is really important in this is also this question of causality.
Yeah.
So one of the developed thesis in the area of big data, right? And this was several theorists have talked about this, is this move from causation to correlation, right? And so big data works without trying to seek causation. It simply tries to discover massive correlations, right? And that's an important piece of your analysis as well. And I was thinking that and of course, that's a very important piece of your suggestion that the law is becoming more factual and less legal, right? So this is the idea that the law is moving from de jure to de facto as a result of these correlations. And I think that to a certain extent that's right. I think that's right. And it would be logically entailed from big data, or the use of what I would call kind of matching logics as applied to legal cases. So just to flesh this out, or to make sense of this, here I can actually give a good example from when I clerked back in 1989 for my judge. And I remember he had gone into chambers and he had looked at all the cases that I had lined up for him, and he came out of chambers and he said, well, I've looked at all the cases and I realized that the rule of law here is that the defendant loses, right? Okay. He was making a joke that, all the cases were pretty bad for the defendant, right? Okay. But that's actually correlation rather than causation. In other words, that's showing that, you look at all the cases and it turns out that the defendant always loses. Now, you don't need to know the causation. The causation is the legal rule as it's spelled out, and the requirement that in order to invoke, say, your Fifth Amendment right to silence, you have to clearly state it during the police questioning that you want to speak with your attorney, and there are lots of legal rules from which we could do a causal reasoning that the result would be you lose. But the fact is that when you look at all of these cases, right?
Yeah.
The defendant loses. And that in a sense is this notion of de facto, right? Rather than the application of a rule, rather than the reasoning, the legal reasoning, listening to the legal reasoning, watching the legal reasoning, trying to make sense of what the outcome would be. Because it's much more outcome determinative, or much more outcome focused on outcome, rather than focused on reasoning, in a way, right?
Yeah.
Go ahead.
How do you say in English adultery?
Adultery.
Adultery?
Adultery,
Yes.
Yeah. There is a very interesting example in French law with adultery. Okay. Because the adultery before 1975, it was a compulsory cause of divorce. If you prove the adultery, divorce was granted automatically. And then the law bans this cause of divorce and said no, it's not only, you don't have only to prove the adultery, you have to prove the impossibility of maintaining the marriage. So it was different. But IT, the review through IT of all decisions about divorce in France showed that adultery was still an important feature taken into account by judges to grant more compensations to the other party. So, and it's interesting because it's only correlation. It's no longer causation, causality.
Causality.
Right.
So it's, you see my point. So
Yeah.
and when we know that, what can we do? The lawyers say, okay, for my client, I know that if I can prove an adultery in this case, I will, my client will obtain more money, which is good for my point of view. But what about judges? And it's the judges. Well, perhaps they are not aware of that. The judges decide case by case, but they don't know what exactly their own case law is. When it's possible to show to judges, look, here what you do, this is the way you decide cases. They are aware of it, and perhaps they will be more cautious and say, the law changed, and I shouldn't give too much weight to the adultery. So it shows that I'm not only negative about this change, this major shift in judging. I think it may improve the consciousness of judges about the way they judge, which is good.
Right. Well, surely what it will do is sometimes change our conceptions of justice itself.
Yeah.
I mean, I think in the prediction context, I think that the reliance on prediction tools and the importance of prediction tools means that we increasingly conceive of just punishment as guided by something like future dangerousness. In other words, it's the very tools themselves that have shifted the way we think about just punishment, so that we used to think of it perhaps more in a retributive way, or for other purposes, maybe more in a therapeutic way in the 1970s. But as a result of the reliance on algorithms and reliance on these prediction tools, our notions of justice have adjusted for the fact that those are present, measurable, valid, apparently, though they're not, but apparently valid, scientific, objective, neutral, etc. And all of that has changed the way that we think about what is a just punishment.
Exactly.
Right?
Yeah.
So that surely seems to be a way in which this digital age is affecting our very notions of justice. But I want to turn to two issues under broad categories, two big issues. One is truth, and the other is power. Okay, because on the first, it's clear that a lot of your intervention is about a notion of of this new digital space being the basis for judgments of truth and belief.
Yeah.
Right. So we should kind of focus on that for a moment. On the second one, I see less in the work here as to how this redistributes power, actually. That seems a little bit more opaque. And so I want to push you a little bit on that to try and figure out how it is that power recirculates as a result of this. But on the first, it's pretty clear that a foundational dimension for you is the way in which these methods become the basis of truth formation, right? Is that fair to say?
Absolutely.
Yeah. Do you want to elaborate on that a bit, or?
Yeah, I mean, the fact of using a large database is a way of thinking that reality is in fact data, which is not. So of course, then this makes big change in what you consider as reality, and this is related to our trust in machines, and trust in algorithms, and this has some anthropological basis. At least in the West, it seems that people would believe that a judgment that the machine can give is better made than by a human judge. And so this is something, very different than what it used to be. And of course, why do we believe that reality should be perceived as data? I mean, this has no justification.
Right.
I would say that this data, and it's a new form of truth, as Foucault would have said. So market is a form of truth, and this computation, it's another form of truth. And so, what is at stake is how judges on how democracy should control, review this truth, which is very difficult actually, and we still don't know how to do that. If I refer the last example of adultery in judicial decisions, I have to take for granted this result. I have no possibility to look into and to know if it is true or not. It's a family matter, but if we are, and more we see civil trials in which there is both party. Let's think about a client of a bank, on a issue of a kind of class action issue. It would be very difficult for a single man to counterweight all the data mined evidence given by the bank in this trial. So it destabilizes the relations of power within the trial because of the difference, the asymmetry between parties. There are parties able to give a lot of scientific evidence through digital analysis of decisions, and other no. And that's the reason why it's the union of lawyers, the equivalent of the American Bar Association in France, decided to make a tool, a digital tool, in order to protect the poor parties in those kinds of cases.
Right. So this is the relationship to power,
Yep.
right?
Yeah.
I mean, and when you were speaking earlier about the revolution, the social revolution to make law more accessible in a sense to people, that also is a question of the circulation of power. So the reason that people are trying to create platforms so that ordinary people can inform themselves of the law is a kind of a democratizing move,
Absolutely.
right? Which would result in a greater circulation of knowledge and ability, right?
Yeah, but once you get this knowledge, this legal knowledge, it's not enough. You have to go to court, or you have to argue with a public administration, which is very difficult. So there is a kind of shift from the role for the role of lawyers. Lawyers are not only information providers. They are they have to nurse or to accompany the parties, their client, to court. And so there's a shift, and because there is now another in terms of power, I think that the digitalizations empowers the client, because the client may have more strength. Let me take an example.
Yeah. Or have more knowledge.
Yes,
right?
not only knowledge, because, for example, I go on a platform and I say, I have a problem, and my problem is the following one. And the platform answers, okay, this is the solution. We think that the legal information is this information, but we received 237 requests in this direction. And if you want, we suggest to make a chat with the others. You know what I mean? So, and I go on the chat on the platform and say, my lawyers told me that, the judges decided that. And so there is a kind of a spontaneous class action for the mutualization of knowledge through chat platforms
Right.
on legal
Right.
issues.
Right. Right. Yeah.
So
yeah.
it's not all negative.
Yeah. No. Well, I mean, I don't know if negative or positive is the issue here. How we would evaluate. I mean, that would be an important thing to evaluate. I mean, pre-digital age, right? There was always this issue of whether your client that you're representing claims to have a lot of knowledge or not.
Yeah.
And so, as someone who represented people on death row, I mean, there was a lot of knowledge circulating on death row about what you have to do, how you have to file, who you want to have as your lawyer, what kind of arguments you want to be making, right? And the more knowledge that circulates, the more conversation you need to have, the more you need to kind of persuade your client that, you know, the course of action that you're taking or that you're suggesting is the right one. There is a democratization of the representation. There's a change in the hierarchy. It's the same thing in the classroom, right? We were on this particular topic on Monday. Right? I mean, if there is a centralization of knowledge and with the centralization of knowledge is going to necessarily create hierarchies that aren't going to be there when there's a democratization and decentralization.
And you can assess your lawyer. You can note your lawyer.
Right.
And it's very new because when the lawyer meets a client, sometimes it's not only one client. The asymmetrical relationship between the lawyer and the client is rebalanced because you have one client, but he talked with 200 people on the case. So that's the first point. Second point, that your client would note you with stars. But he doesn't know law. So if you think that the good strategy is to file a case on this ground, he cannot assess your choice. But he can assess the experience of the way he was received by the lawyer, the efficiency if you talk with him, if you are kind with him, and so on. So the experience, the client experience. So it's a change in the relation of power between the lawyer and the clients, and the people.
Right.
But I could, yeah, I might add something about this because I mean, you were mentioning how power circulates in new ways, but it's also there's an emergence of opinion, you know, through these chats, and so this is very difficult to control in a way. And we see that on social networks, you know, that opinions become viral. And so this is also new forms of circulation of information that are very, very difficult to control.
Right, yeah. Well, I mean, I think we see it, for instance, with the Uber phenomenon, right, where all of the scoring and ranking is part of the way that the system works.
Yeah, absolutely.
It's part of the way in which security is obtained, or a sense of security. And so the digitization is serving other functions than the ones that it was designed to do, right? But it does end up providing, for instance, a sense of safety, 5 stars, lots of stars. You know, this person seems reliable. It's a way in which that function then gets repurposed, right? Repurposed, but also that we are now doing the work of predicting. We are doing the, well, this is this notion of surplus value, or that some have spoken about, the way in which in the digital age we are doing a lot of the work, internalizing a lot of the work that is necessary for the political economy to function. Right. Yeah.
But it also works as a self-assessment for lawyers and for judges, and so it's not only the assessment by clients, but it's also it's very interesting when you again when you are a judge, even for a lawyer, you don't necessarily know exactly what you do as a mass of decisions. So you know what you do in every case, but if there is a problem about the predictability of justice and judicial decisions, which is a quality, a sign of quality of justice, but not necessarily, because sometimes the judicial decisions must change. So it's very interesting. It can be very interesting in a court, for example, just to, and it's done by platforms such as Lex Machina in the US. You can assess not only lawyers and law firms to see what are the most successful law firms in that kind of case, which is it's very important information given to litigants. Now the litigants can know because they have a kind of scan of law firms. The same for judges. They know which how often a judge is quoted by his fellow judges in federal circuits. So there is an assessment, a general assessment of lawyers, judges, and whereas before there was nothing of that. You were. It was just a matter of belief, of reputation.
Right.
And it changes the reputations of lawyers. There are side effects, of course, bad effects, but it's a total change. This is my that I want to stress.
Good. It might be good to open the conversation up and see if there are some questions. And we do have a mic. And Charlene, do you want to start? And then Charlene.
Yes. Not really.
I'm not sure.
Not sure. Yes.
Oh, right now?
No.
Not better.
Oh, good. No, you can speak. Yeah.
Hold on.
Okay.
There we go.
There we go.
Thank you. Hi, my name is Charlene. I have 2 questions or 2 points. The first one is on the question of inevitability and especially in the way you presented the development of the digital in the beginning throughout the philosophy of science. And I mean, to me, instinctively, I mean, as much as I see the value of understanding the digital as something coming from, you know, the history of computation and also the history of writing, what bothers me in the tech discourse currently is precisely that sense of inevitability. So this is a natural, has a very long history, it's just a natural development of the technology. Whereas, especially when we question the digital through the spectrum of justice, it seems to me that shouldn't we question the kind of developments, and especially the algorithmic development, especially the surveillance built into it. So it's just on a point of the inevitability of it, and I don't know how if you tackle that question in the book. My
We do,
second
actually.
point. Sorry.
Yeah, we do.
Okay.
Yeah.
So I'm interested in.
Okay, right.
And the second point relates to, well, the question of truth, but also of truth and the narrative. So, in two ways. The first thing is that, yes, I understand how, I mean, and you made a really good point on, I mean, you explained at great length how the digital is changing the way the judge reads the narrative. But what about the way in which the subject who is in front, who is in trial, his own narrative is transformed? And I'm thinking of the metadata, but also of the digital evidences that we leave around. And there's this book that Professor Harcourt edited in English, but by Michel Foucault, Wrongdoing, Truth-Telling, The Role of Avowal in Justice. And I'm not a legal student, but my understanding of it is that liberal justice is based, or has at one of his bases, the fact that a man is judged also through his intention, not only through what he did. And usually the intention is what you express. And very often in a case, or you cannot, I mean, there's no way to factually prove an intention, right? It is what you say, it is who you say you are. So this relates to truth-telling about oneself. And metadata and the digital seems to be completely transforming that. And in trials maybe. So I'm wondering, do you as a judge, have you ever judged someone, or are you aware of a case where someone was judged not on what he said his intention was, but on what the data, or the digital data said he meant or wanted to, or who he was? And there's always, I mean, I usually, when I question that, I usually use the first cute little scandal about Pokemon Go. And I think the first week that Pokemon Go came out in the US, everybody was talking about it, and there was an article in the New York Times about how it broke relationships. Because a girlfriend, asked his boyfriend, "Oh, where were you this afternoon?" And he said, "Well, I was at the library." And she was like, "No, you caught a Pokemon in front of your ex-girlfriend's building, and I'm leaving you." And the article in the New York Times was quoting that boyfriend saying, "It really is a mistake." And he had a big story, he had a narrative. Right. But the data just disproved it in such a radical way that his own narrative just, it didn't matter anymore. I mean, it just fell apart. And maybe he was innocent. Who knows? But this is something, I mean, I'm wondering, in real, this is a cute story, it's not that bad, but what about in, more important or like life-threatening or life-changing cases? And I'm very brief, always on truth and justice. I don't know, again, I haven't read your book yet, but I wonder if you talk about this, but to me, one of the most important revolution is, well, Me Too, for example. It is a gigantic revolution in justice. Do you call that justice as a judge? But suddenly the capacity to tell the truth, or to tell one's own truth, which brings justice, and sometimes injustice it has been. But I'm wondering, how do you see that, and how do you see the relationship between the digital, the truth-telling online, and how justice should be made?
Thank you, Charlene.
Thank you.
Shall we start with
okay, so we'll start with
inevitability?
inevitability.
Yes.
Yeah, it's certainly something that we hear a lot, and well, there's at least one thing to say, is that when you take computation, the real the important theorem on computation is not about computation, it's about the uncomputable. So that's something very important. It's in what the philosophy of science called negative theorems. So what Turing proved, for example, is that all the mechanical processes cannot be computed. Okay, so there is this dimension of non-computability is most of the time, put aside, and we will just, mention the fact that computation can expand. And it's true, it can expand, but there's another dimension, which is the uncomputable, which is always there. So there is something to argue about this inevitability, because there is, of course, some kind of expansion of software, but this expansion, the meaning of this expansion, is always should be also, how could I say that? Should rely on the fact that there is, from a logical point of view, there are processes that cannot be computed and won't be computed ever. So you see what I mean? So of course, if you take these two dimensions together, the whole notion of inevitability, if I can say it, inevitability changes, of course. You see what I mean? Okay, right. So maybe you will answer the second one?
Yes, it's a very good point about I would say that the strength of Foucault's reading, that they provide us with the long history of truth making, of the Jewish truth making, and to this extent, I would answer yes. We could say that the digital, the quantification of data is a new form of truth. It's a new form of truth. Why? Because we can find major features of the form of truth. The first feature is the power we already spoke about, but the second feature is a matter of common beliefs. There is a common beliefs, and there are beliefs. And one a major point in our book is to say there is a kind of delegation to machines, which is a myth. We just don't understand, and I don't know how to say in English the prolepts.
Proleptic? There's a rhetoric figure.
Yes. If you just hear what is said about that predictive justice, there are a lot of announcements, statements that will happen, and there is no other way. There is something inevitable. Read, for example, I take the success of Yuval Noah Harari. It's only predictions. It's a prophet. And about what will happen in the future, he speaks about this is inevitable. This will happen tomorrow. And it's a quotation of Yuval Harari. He says that tomorrow we could find the truth. He speaks about the truth through mental scanning. There is a quotation in French, but
if I can just say something about this proleptic rhetoric way of seeing things is always to say that the future is inevitable, and because of this, we have to confirm our behavior today the way the future will be. So there's some kind of vicious circle in this, and it's all the time. The future is now. And so since the future is now, you have to conform yourself to this future.
In his last book, Harari writes that tomorrow it will only through a click we could find the truth or the lie if a man tells the truth or lies through mental imaging, which is a total myth. It's stupid, but it's taken for granted, and it's a big success. And the third point, the third feature is subjectivation. I don't know the subjectivation. Yeah. It means I'm speaking about the quantified self. That the relationship to oneself is passes through quantification. So we can find and we can find a lot of features of what Foucault says about the forms of truth, and I recently showed how in the evolution of the judicial judgment, starting from formal evidence in court, and then through the examination, and then through quantification. It's a continuing history. So we could say that which is new is there is not an lethargy, but the entire, the exactly opposite. The ideology of hackers is to they define themselves as anti-institutions, away, totally exterior, outside institutions. In his proxy for opening the capital of Facebook, Mark Zuckerberg defined itself as a hacker. Come on, the most powerful, perhaps, man in the world. One of he owns the platform. He can change the relationship of more than 2 billion of individuals to the world, just changing an algorithms. And he still defines himself as an outsider, as a hacker, as something totally away from institutions, whereas he is in new institutions, a kind of. So I think it's it's not a definitive answer, but we should work in this way, and use the tools of Foucault, the idea of forms of truth.
Okay, let's take another question.
Yeah, my name is David, and my question is a couple of observations. In this country, we have incentivized testimony, otherwise known as perjury. And I'm wondering how the judges in France determine that an individual is actually telling the truth or not. And we have a number of wrongful convictions. I think Cy Vance acknowledged 200 wrongful convictions, and the defense bar said it's actually a minimum of 10x that. So maybe you could address those issues.
Yes, the French system of reaching the truth, we could say, is very different. So what happens in France? The judge has the file, which is a compilation of every written stuff since the beginning of the case, through the police station, and there's the first statements, and then there is an investigating judge who hears witnesses, and then the formal hearing, public hearing, and then how do? We compare what a witness says in the formal hearing with the previous declarations, and with the previous declarations of other people involved in the case. So the mechanism, the very mechanism of judges, it's always comparing. There is no such a thing as credibility in our system. There is no credibility. It's not as strong as it is in the US. It's more a matter of consistency of witness statements. Okay. I don't know if I answer your question.
Yeah, good. Let's take a last question from Clesio. Do we have the mic?
Good evening. I have 2 points. The first one is when I'm listening to you talking about the actual patterns of judgment, like making more clear all the prejudices that we're always using, but we didn't have this written but yeah. And something comes to my mind that when Foucault was what Foucault was saying in Discipline and Punish, that the discourse of the criminal justice uses this kind of sense of being legal, being distant of the case, being formal and with no prejudice at all, and acts being prejudiced. So this is exactly one point really important for the function of the justice, just not saying that it is, but being. You know what I mean? Like acting, pretending not being prejudiced, but being prejudiced. So this point is really important for the function of the judicial power. Yeah, and I think that with these formulas, this rigid, like if the person is black, if the person had committed a crime previously, then you point out and you judge. The prejudice is really clear. It's not fake anymore. So I'm wondering if the function of the justice will change a little with these things coming up to everybody. Now everybody knows how judges judge, you know, using these formulas, okay? This is the first point. And the second point that I would ask is that Professor Harcourt asked about power and truth, and I would ask about the third point of Foucault of the 80s, that would be subjectivity and subjectification, better this way, yeah. And how do you think that these changes in digital justice can or will be changing the subjectivity of the people that are judged, the people that are in justice, and in people in general, how they face the justice, you know, because obviously the way that justice acts, it influences it is a way of subjectification as well, you know. So these are the 2 points that I'm...
Yeah, there are many issues you raised, but one of them, it's very, we have to look carefully what actually judges do with those compass and other stuff, because there is a study from Professor Christin from Stanford. She went to courts to see how judges applied compass, you know, the program compass, which was the scoring of individuals, dangerous, so. And she discovered that judges are extremely reluctant in enforcing those systems. Why? Because they said, look, I was elected or appointed as a judge. I'm an old lawyer. I'm not paid for looking at scores and just applying scores. I want to do my job. And my job is to try to give justice. So with a part of subjectivity. So what is interesting in this observation by Professor Christin, again, it's to see that in reality, we have to be very careful about what really happens in court. My second point is we are doing in my institute a seminar about law and computation, law and mathematics, and we try to understand you know, when you are a judge, and it refers to a question here, when you are a judge, you are facing individuals. And I was a juvenile court judge, and there is a dimension of justice for everybody, mainly for juveniles, that you ask people to take undertakings before the judge, to
Commit.
To commit. I won't do that. I'll try to do that, and it's a very important dimension of the business of judging. And there is a case related in our seminar by a judge who said he received a man classified as extremely dangerous, not only dangerous, extremely dangerous. And the police squad told him he is so dangerous that we could stay in your office for the interview because he could kill you. And it was what's the enfant soldat? It was an
Child soldier.
Child soldier from Africa, and we committed a lot of extreme violence since the age of 10, and who never knew his father, because it was the case, roughly. And the judge decided not to take into account only the security score, but to consider this
The narrative,
yes,
and the story.
and he said, no, okay, I'll make the bet. I don't know how to say that in English.
I'll take the risk.
I take the risk to talk to him as an individual, and to ask him to tell me what's his story, where he's coming from, which part of Africa, what was the problems with the civil war in RDC, in Congo, and what did he knew about his father. And this extremely dangerous guy started crying, and it changes totally the judicial hearing. And at the end of the hearing, it was no longer a matter of safety. It was a matter of education, probation, what you want, and it worked. It worked. He wasn't remanded in custody. So my point is that the judges shouldn't stay blocked into the scoring of the business of judging is not only a matter of security; it's also a matter of human interactions.
If I
Final
can
thoughts,
say,
yeah.
just one word about subjectivity, and I mean it goes in the same direction as what you just said. I was thinking of Honnet's recognition struggle, and of course, people who are in court want to be recognized in their suffering, in the fact of being victims, etc. So this is also a big issue, I think, with digital justice, is will it bring the same kind of recognition? You see? And I'm not sure about that. It's an open question.
Yeah. And just on that point, I mean, there's also a bit of an illusion of transparency. So, I mean, for instance, a lot of the tools themselves are business secrets, so you can't actually find out what's in the black box that gives the algorithm. But even when it's not, usually people don't actually scratch underneath the surface to figure out what are the factors that are being used in the prediction tool. So there is an illusion that, well, it's going to be less biased because we'll be able to see what's in there, but it turns out that we rarely see what's in there. We rarely pay attention to what's in there. At least for algorithms. And of course, for artificial intelligence, the real problem with artificial intelligence is that it's really mimicking the patterns that have existed over the past decade, or however much your big data covers. And those patterns are going to have in them all of the prejudices that have existed over the past decades. So the artificial intelligence prediction of what the outcome would be is not going to be cleansed of all of the gender racial and other forms of discrimination that produced those outcomes that it's trying to mimic, right? So I think that the notion of transparency is a real illusion in this context.
Yeah, absolutely. Yeah.
All right, well, please join me in thanking Jean and Antoine